Hey everybody, how's it going? My name is Will and welcome to Copper Jacket TV. So I think pretty much everybody out there understands that the Ninth Circuit is a joke when it comes to 2A cases. I mean, that's why we call them the Ninth Circus, because it is a court that is filled with judicial activists, judges who would rather see their own personal agenda achieved than uphold the rule of law and support the Constitution. And that's why in its over 130-year existence, it wasn't until this month that we actually got our very first ever Second Amendment win that was finalized at the Ninth Circuit. So since 1891, this is the first time we ever had a case that was finalized that was a win for the 2A, and that was in a case called Nguyen v. Bonta. Now, the only reason we actually won that case is because in a very rare instance, the state of California did not request a rehearing en banc, and the three-judge panel's decision was allowed to stand. But in every single 2A case that came before it, the case was taken en banc. Even if we got the win, the three-judge panel's decision was reversed, and the Ninth Circuit always sides with the state when it comes to our 2A rights. Well, now in another very important 2A case that we just talked about in yesterday's video called Ukitake v. Lopez, the Ninth Circuit has done it again. They have reversed the three-judge panel's decision, which was a win for us and a win for the 2A over the state, and decided to take the case en banc. This is a very rare scenario. As a matter of fact, when it comes to cases in front of the Ninth Circuit, they only take less than 2% per year. So all the cases that go up before the Ninth Circuit, less than 2% are actually reheard en banc. But when it comes to the 2A, 100% of the cases are heard en banc. So this means that more than likely, just based on history, the Ninth Circuit is going to once again side with the state on a law that is so clearly unconstitutional, it is impossible to deny. Well, in a rare turn of events, an amicus brief has been filed at the Ninth Circuit in support of Ukitake that was written by our good friend Kostas Moros of the 2AF and also supported by the CRPA that absolutely rips into the Ninth Circuit. Now, I'm telling you right now, you don't usually see briefs like this, and I am here for it because this is the first time that I've ever seen the Ninth Circuit actually put in their place, where the Ninth Circuit is faced with its history, its 130-plus year history of not allowing the Second Amendment to win in their court. And the Ninth Circuit covers a huge area, all the way from Montana and Idaho to Arizona, Nevada, California, Oregon, Washington, Hawaii, and so forth. The Ninth Circuit has been a joke this entire time. Let me show you guys what this brief actually says. Okay, so here's the brief from the Second Amendment Foundation, California Rifle and Pistol Association, and the Second Amendment Law Center. Okay, so here's what he wrote right here, and like I said before, I've never heard anybody actually say this to the Ninth Circuit, but this is definitely something that needed to be said, where he writes, "The vacated three-judge panel ruling reached the correct result because there is simply no historical tradition of requiring gun purchasers to endure both an arbitrary time limit to complete a purchase, nor to force them to bring their new firearm in for police inspection, as Hawaii revised statutes respectively require. Were that all that amici had to say on the matter, this brief would be unnecessary, as plaintiffs' appellees' briefing makes their arguments well, and amici join them in full. But amici are compelled to make their voice heard because, as they are frequent litigants in this court, they too have had hard-won and costly Second Amendment victories stripped away from them upon en banc rehearing. For most other types of litigants in the Ninth Circuit, en banc rehearing is statistically almost as rare as a Supreme Court cert grant, and prevailing parties after a three-judge panel almost always get to keep their victories. But rehearing is practically a matter of course in this court whenever litigants challenging gun laws prevail on final judgment before a three-judge panel, with only one very recent exception in which an en banc did not occur because the state of California did not petition for a rehearing. Every appellate victory for the Second Amendment has been reversed en banc. The added extra step for Second Amendment plaintiffs not only erodes confidence in the fundamental fairness of this court, but it also taxes the already limited resources of nonprofit advocacy groups that must go up against taxpayer-funded state governments with seemingly unlimited litigation resources. In this brief, amici will review this court's habit of granting en banc rehearing in Second Amendment cases, demonstrating why it is so damaging to both plaintiffs turning to the courts for redress of grievances, as well as the reputation of this court itself. Amici believe this rehearing should be withdrawn and the panel ruling should be reinstated. Failing that, however, amici also argue that this court should use this as an opportunity to reverse the damaging standard in Second Amendment cases set forward in B&L Productions v. Newsom and clarify what is required in the plaintext analysis of such cases. With the correct standard in place, why revised statutes clearly implicate the plain text of the Second Amendment, and because they lack any supporting historical tradition, they should be struck down. So as you can see right there, Kostas just goes beast mode on the Ninth Circuit. I mean, he points out every flaw with the Ninth Circuit's decision-making in the past, every single flaw with the loss of trust and faith in the court itself, every single decision that they have made on the Second Amendment that has been overturned or corrected by the Supreme Court. And the outrageous stance that the Ninth Circuit has taken in the past, which is just outrageous. So I thought I would share that with you. I mean, that is a really big deal to have a brief filed like that. Again, that not only just supports Yukatake and supports, a pro-Second Amendment agenda here, but one that just absolutely shreds the Ninth Circuit. And that's something that I think we need to see a lot more of. The Ninth Circuit being put in their place. They've been put in their place by the Supreme Court before, but you don't usually see it in amicus briefs like this. So this was really exciting to read, and I thought that it was written really well. So anyway, I wanted to share that with you and just let you know that another 2A case is going on bonk, and that this time it's got people pointing out some pretty big flaws up at the Ninth Circuit. So I want to thank you all very much for watching. I really do appreciate it. If you haven't done so already, make sure you hit that subscribe button. Likes are always appreciated as well, and y'all have a great day.